life.
And then I just shipping up the
Hello, can you hear me?
Hello, hi.
Hi. Yeah, good afternoon all, or good morning, depending on where you follow this webinar. So we are going to have a webinar on understanding Rwanda's data protection law, a global perspective on compliance. I started by introducing myself. I am Cyrus Majambere, a lecturer from University of Rwanda and a PhD student in data science for healthcare in Stockholm University, Sweden. So we are going to have this webinar in 3 sessions. The first session is about understanding Rwanda's data protection and the privacy law. So it is a good opportunity to know what is in this data protection law and the privacy that we have to follow. So the next session, we explore the international data protection laws, and this will be given by Kaimba. I don't know if I pronounce well your name. And the last session will be on cybersecurity and data protection compliance. So this webinar is very important as we are in the age of data where we produce a lot of data every day, and we should be knowing what our data is used for, and whether companies which are using our data follow data protection laws. So we know compliance is very useful in order to make sure that our data is protected and it doesn't create any harm to users. So data protection law is about protecting users' data and the best way to use these technologies, mostly which are introduced to our daily life. We should be protected by laws. And non-compliance is always penalized. We saw in different occasions European punishing Google for non-compliance to general data protection regulation of Europe. So we are going to see more in this webinar, and we'll have a chance to ask questions. So I would like to call upon data protection officer who is going to speak on behalf of representative from National Cybersecurity Authority, who is not available for today's webinar. Thank you, and I welcome to this important webinar.
Thank you so much. I hope I can be seen clearly.
Yes, I see you clearly.
Thank you so much. My name is Rosine Mujawimana, and I'm the DPO, Data Protection Officer of Africa Quantitative Sciences, that is hosting this webinar. So we are going to share just ideas and go through the data protection law. Let me present.
Yeah, I stop sharing.
Okay. I hope you can see my presentation.
Yes.
So before we go on with this data protection law of Rwanda, I would say it's new, and it was enacted in 2021. I was told in this webinar we're going to have people from different organizations, and many of them had heard of the law, and I think from other participants is going to be it's new. They are not aware of the law. So it was it was enacted in 2021, and it's a new law. Many people are aware, others are not. But for this webinar, we're going to discuss about it, and we explore more about this law. I hope this can be seen clearly, right?
Yes.
We see it clear.
Sure. So data protection law of Rwanda, same as other data protection law, it has principles. The first one include lawfulness, fairness, and transparency. By lawfulness, this means that I will use examples since we're going to have people from different organizations. This means that organization must collect and use personal data in a way that is legally, and that is ethical, and that is fair. Let me use example. For example, if you collect personal data, let's say an example of a hospital, let's say Hashika or King Pfizer. It doesn't mean they do it. I'm using examples. Let's say they collect personal data of a patient or an employee, and this personal data is used in other ways other than the purpose it was collected for. And then the second part is about purpose limitations. Let's say if a health institution or a hospital, let me use a simple example. Let's say the COVID test 19 center used to collect our phone number just for getting to know where you are, who you are, and getting to know the result of your COVID-19 test. Imagine using that phone number for also sending you advertisements that are not related to medical information. They collected your phone number just for informing to know who you are and the status of your COVID-19 test. And then imagine they are also using that phone number or your email for sending you advertisements that may be related to food or other things. So organization must collect data and use it for the purpose it was collected for. And also on the part of data minimization, meaning that you collect data you only need. Let's say, imagine going to a restaurant and instead of asking you your name or your phone number to know if you have paid, they are asking you for your ID. It doesn't make sense. You just collect data that you're going to need to use. On the part of accuracy, data needs to be clear and needs to be updated. Let's say in a hospital, imagine on a hospital, imagine recording that this patient is allergic, for example, to peanut butter. So why the patient is not. The description of the pills and the medicine are going to be different because of the error they did in collecting the data of a patient. Or imagine in a hospital sending an ambulance to a wrong address just because the address is incorrect. So the organizations needs to make sure that the data they are collecting its accuracy. Or another example, simple example. Imagine recording incorrect finance or account number of an employee. the salary is going to be sent to a wrong bank account. So it's in that way that the law requires organization to keep data with accuracy. And another point we're going to talk about is storage limitation. The law requires organization to pay more attention on the storage limitation. You don't need to keep data that you're no longer using. For example, if a hospital collected data to do some research, if that research is done, you can destroy that data you collected, unless it's legally required to keep the data. And on the other part, we're going to talk about integrity and confidentiality. Integrity and confidentiality of the law that it requires the organization to implement is to make sure that you take more serious the security of the data you collected. Your organization must implement secure measures. This may include encryption, this may include a strong password policy, and extra. But they have to take it seriously when it comes to security of the data collected. I just want to keep this presentation short. I don't want to bother you. And yes. And lastly is accountability. By accountability, I mean organization must take accountability for the data they collected, either for the employees, either for the clients. It depends on the data subject of the data. So they must take accountability of the compliance. They have to be compliant to the law for the data they have collected. It just, I hope, are you still seeing my screen well?
Yes, we see it
Yes,
clearly.
we see you.
Okay, good. You have to excuse me. We are just trying to get to the basics of the law. Since you have different people in this webinar, some of them, the level of understanding about the law is higher, and then others are not. But we just want to know the basics of the law, so we get more into the law after. Rights of data subject. I would say many people doesn't really even understand what data subject is. A data subject is a person or the owner of the data. Let's say in an organization. In an organization, a data subject could be an employee, a data subject could be a client, a data subject could be a supplier, a data subject could be a third party or a partner of the organizations. So this data subject, they have rights. Of course, they have right to access personal data they've given. An employee has rights to access his or her personal data. Also, they have rights for rectification. Rectification is more of updates. Yes. Updates means I was using this phone number, but now it's changed. You can change it. So to the part of an employee, I had an account or bank account in Beka, Bank of Kigali, but now I shift. I'm in Equity. So they have a right to update their personal data they have provided to the organization. They also have right to erasure. Many people, many organizations or many DPOs we've discussed, when it comes to rights of erasure, they're like, how comes? But also, they're subject to they have right to erasure. They have right to say, okay, you're no longer using my data. I need you to delete it. Yeah, they do also have that right. And then a right to restrict processing. Processing of means, okay, let's use an example. An hospital could collect personal data of patients, and they would need to share that personal data to pharmaceutical companies. The data subject have to give consent for that processing. You collected my data just to give me health services, but I did not agree on sharing it to third parties. Third parties, this include pharmaceutical companies or insurance companies. I could say, okay, I don't need you to share my data to pharmaceutical companies. I just wanted you to keep my data in the organization. And then we also have right to data portability. Data portability, this might include, okay, you have this information of mine. I want it to transfer to other institution. Let's use an example, a hospital. You were once a patient at CHUK, but now you're transferring to King Faisal. So they have to give you the medical records from CHUK, and then you transfer it to King Faisal. That's the right of the data portability. And also we have the right to object. I do not want to give my consent. I don't want to give my personal data. Yes, and they also have rights related to automated decision making and profiling. This is more of if a company or a hospital. Sorry, I'm using hospital so much because we have worked with many people from health sectors. I got to know some of their operations. Yeah, sorry. So rights related to automated decision making. Maybe a hospital may say, okay, we are going to be using this AI tool. We are going to be using this algorithm. So a data subject has right to consent whether they can use those data in that AI or an algorithm, or they cannot. And here we're going to talk about the organization's responsibilities. I want us to focus more on this. When it comes to law, especially data protection law, they ask you to register first as a data controller or a data processor. So registering and having a certificate of a data controller and a data processor does not mean that you're fully compliant. You need to take more steps, more responsibilities. So registering, it's one step to being compliant, but that's not all. So when we're going to talk about this responsibility of an organization, the first thing I want to emphasize on is valid consent, obtaining valid consent from data subject. Well, failing to comply with law comes with fines and a big cost of company's reputation. That's why it's really important to focus on the part of being compliant with the law. When it comes to valid consent, I mean everything you do, everything that is done within an organization, we have to have a consent of it from the data subject. Many of the organization prefer to import to put the consent within the website, whether privacy policy or any other different ways, but you have to get a valid consent from the data subject. And the second part is implementing security measures to protect data. Protecting data doesn't mean you own it, doesn't mean that's your data. You have also to protect it, to implement security measures. Either, I've given examples before, the encryption or the password policy and everything. And on the part of conducting data protection impact assessment. Okay, let me start by explaining what data protection impact assessment is. In other words, is DPIAs. This is a process that is done when trying to identify risks that might come from processing personal data. The law requires us to carry out DPIAs or data protection impact assessment on highly risk projects, processing activities. But I recommend organization doing it on every project. Every project that is going to process personal data, you carry out DPIA. DPIA is National Cybersecurity Authority on their platform. They provide a template. They provide a template so it will be easier for organization to carry out a data protection impact assessment. And then another point is appointing a data protection officer. Well, here it says where required, but the law requires every organization to appoint a data protection officer. The most mistakes companies make is just appointing a DPO. A DPO has to have some requirements. You can just get a guy from the IT and then you point him as a DPO. No, it doesn't mean that he's qualified. A DPO has first to understand the operations of the company, which is good. And then the second, the data protection officer also has to have the knowledge about the law. So it will be easier to implement law into the organization's operations. That's why. So this is the most mistakes companies do, just appointing a DPO. And another point is reporting data breaches to authorities and affected individuals. The law requires organization to report a data breach to National Cybersecurity Authority within 72 hours. So there is two ways. If there is a data breach, you inform the regulators and also inform the data subject. The data subject, the owner of the data. It's two ways. And then lastly, maintaining data processing records. Every records, you should maintain a record of every activities that is done on the data on a data collected from the data subject. And another part, well, hearing all of this, the law, Article 1 says this, Article 2 says this, you could say, oh, this is overwhelming, this is too much. How can I do this? Where can I start? From the first to the last. First of all, I'm here to just show you step-by-step guide on compliance journey. Wait, this is not only it. You might need to do more research, but these are the main. First of all, you have to understand that there is a Rwanda data protection law. You have to know that there is law first, and then understand what it says. And then secondly, you conduct a data audit. Identify within the company, you could say you identify what kind of data you collect, whose data, how you collect it, how it's stored, and for how long it is going to be stored. After understanding that, you get to the point of saying, okay, so I should put a person in charge of this compliance journey. I have to put a person. That person has to understand the company's operations and has to have knowledge about the law. And then the fourth thing, you should say, okay, we have what kind of data we collect. We know whose data. We know where this data is stored, and we know why it is stored, why it is collected. So what are the security measures do we have in place? Are they enough? Which ones can we improve? And then the fifth one is about developing privacy policy and compliance framework. Developing, the law requires us, I think, like almost 15 documents. I will try to go on, I don't remember all of it, but some of them are the breach notification, cookie policies, privacy policies, data subject consent withdrawal, data retention policies, and also carrying out inventory processing activities. And then the sixth one, you have to train employees that they have to know about the law. There's this video the National Cybersecurity released, employees discussing about a patient. They were like, oh, she's been having cancer for 6 years. That's not correct. That's not correct. So you train staff on the data protection laws and the best practices and the privacy. On the seventh part is conducting regular compliance and audits. After doing everything, setting up implementing policies, having security measures in place, you audit yourself. You'd be like, okay, the first article says this, the second article says this. So are we compliant? Are we doing it as we should be doing it? On the last part is ensuring ongoing monitoring and updates. So you keep ensuring that things are going the way it should be going. We have a few minutes. And another thing I needed to share with you is assessing your data environment. This is very important, like very important. First thing, it's so hard to be compliant to the law while you don't even understand the operations or the data flow within the organizations. The first thing you need to do is identifying the types of data collected. Types of data, some of them are sensitive, some of them are just personal. I could say like names and emails that are just personal, and then sensitive, it's, for example, a criminal record, an employee criminal record, that's sensitive. So you identify what type of data do we collect. Okay, we collect just personal data, and we also collect sensitive data. It's in that case you will know how to implement security measures. You implement high security measure for the sensitive data, and then you could also say, okay, this is personal data, it could be retained this period. Yes. And then on the second part is determining lawful processing basis. On the part of lawful processing basis, this means why are you let's say which gives you right to process this personal data. Why are you processing it, and what gives you right to do it? You could say a concern. We could say I'm processing this personal data because the owner of the data allowed me to. Lawful processing basis could also be a contractual necessity. A contractual necessity means I'm processing this data to provide a service. Let me use example. An employee gives you her or his financial account, bank account, because she needs you to pay her or him. That's the grounds for processing. It's contractual necessity. And then the third one is map data flow within the organization. You could say, okay, in this organization, we have the receptionist, we have HR, we have finance. This reception collects this data, HR collects this data, finance collects this data. And how does those data connect to each other? The receptionist gets the phone number, the emails, the names of the guests or anyone. But the HR collects employees' data, and the finance collects the way that the employees' data or the company data could related to finance. So you know how they connect from the HR to finance. HR to finance, they share this data. The bank account, that's what they share. So understanding the flow of the data, and then you map it. Data comes from here, goes there, and goes there, and then you map it, you connect it how they connect. And then the last one, evaluating third-party data sharing practices. Oh, I love this one. Evaluating third-party data sharing practices. You could ask yourself, what does third-party mean? Third-party means another person who's not the data subject and the data controller. For example, a patient and a hospital. So a patient is a data subject to a hospital. And also a hospital works with, they have partners like insurance companies or pharmaceutical companies. So those pharmaceutical companies and insurance companies are the third party, like the third person. I hope you understand. So you don't freely share your data with third parties, even if you are partners. You don't freely share it. You have to have a clear consent of the data subject. And for you to share data with the third parties, for a hospital to share data with insurance companies or pharmaceutical companies, they have to have an agreement. That agreement is called a data processing agreement. That data processing agreement is given by, it should be given by the hospital to the insurance company or to the pharmaceutical company, agreeing, I'm giving you this data just for this purpose. You do not use this data beyond what we agreed on, and you agree to provide these security measures for this personal data I'm providing to you. Yes, and then on the part of risk assessment and DPIAs, this is more of calculating the risks that might arise from the activities that the organization is doing. The first thing, identifying potential risk for personal data. Potential risk for personal data, you could say, in an organization, we have many physical files. So the potential risk for this personal data that are on physical files, they could be stolen or they could be mishandled. Mishandled is, it happens in some organization. You could, you visit this organization and then you step on somebody's CVs or you step on somebody's contract. It shouldn't happen. You identify the risks that might arise from processing personal data. And then the second is assessing impact on data subject. Okay, how are my data subject going to be affected? Imagine, some people used to give examples that you should, sometimes you go and in a public supermarket, and then they'll pack snacks in your CV that you applied in any organization. That's shameful. So you have to be to assess the impact that data subject might get from your way of mishandling their data. It comes more understandable and stronger when we go to the health sectors. Imagine finding out, people with HIV, they are somehow confidential about it. Imagine finding out that somebody has HIV. It's going to affect the person with HIV because of the rumors they're going to be talking about him or her. So you have to calculate the impact data subject might get from your way of mishandling their data. And then the third one is implementing risk mitigation and strategies. So what can I do to avoid this? If I have many physical files and they might be mishandled or thrown everywhere, what can I do? Either I reduce physical files and then increase more digital ways of keeping this data. And the fourth one will be conducting DPIS for high-risk processing activities. We talked about this on the above slides about DPIAs. Yes, law requires us to process to conduct DPIS for high-risk processing activities, but to be so sure that you're fully compliant, I recommend doing it on every project. Let's say an organization A is going to be working with another organization outside of Rwanda, like they're going to host their data. Let's say many organizations use cloud-based services or cloud-based softwares. Well, first of all, that's not allowed based on the law. You should request for the authority to allow you to do that. But when it comes to conducting DPIs, you can conduct a DPI. What risk would come from sharing our data with outside people outside of the country? So you carry out this. We are sharing them this data because of this purpose, and it should. The risk is that these third parties, they are not operating in Rwanda. How can we be sure that they have necessary security measures? And lastly is maintaining documentation of assessments and action taken. So after all of that you've done, you have to have a documentation of it. If you carried out regular audits, if you give an employees trainings, you have to document it as a proof that you make compliant, you take compliance seriously. And lastly, I don't want to take much time. It's creating and implementing policies. Yes, we talked about this. The data protection policy should be implemented, data retention and deletion policies, and also the guidelines for consent management, making sure that third-party processors comply with regulations, and update policies to align with legal changes. I think this is the last one, hopefully. The way of managing data subject. We have seen the rights of data subjects. You should implement the procedures for them to exercise their rights. and you should respond to them within a period of time. The law requires us 30 days. Yeah. And another point is establishing instant response protocols for data breaches. Okay, we had an incident where data is breached. So what can we do? What's the way to move forward? And what do we need to make sure that this doesn't happen again? And conducting post-incident evaluation to prevent future breaches is to exercise the measures you've put in you have in place so that data breaches can't happen again. Well, also the benefits of being compliant, I think we know some of them. For the organization, you build trust for between you and the clients and the partners, and you avoid legal penalties. You enhance cybersecurity resilience, and it also improves operation efficiency. For individuals, you protect their personal privacy, and then it gives them the control over personal data. It reduces risks, and it also enhances confidence. Yes, I think that was it. Okay. Before I give the floor to other people, I would say Africa Quantitative Sciences provides these services. They help you from the journey of being from 0 to 100 compliant. We usually implement roadmaps for the different companies. We develop roadmap for you from 0 to 100 being compliant, and also we help you to implement it from the first step to the last step. So I think we've worked with different companies. We've worked with Sehashika, I think they're in here. We've worked with Noskin. Hopefully they've joined the webinar. We've worked with Skoll and other different companies. We help them to be compliant to the data protection law. So that was it. Sorry, I took a lot of time. I didn't know I would say much, but thank you so much. Thank you so much. Yeah.
Yeah, thank you, Rosine, for your nice presentation. Now we are aware what is in data protection law in Rwanda. We have questions online, but I hope we can wait until we reach the QA session. So if you allow or you prefer to answer the questions before we move to the next session. Okay, so we go to next session. So the next session is on exploring international data protection laws, which is going to be given by Brensil Kaimba. So you can take the floor. So welcome.
Thank you so much. Just Silas, just confirm you can hear me.
Yeah, I hear you very well, 100%.
Okay, great. Thank you for the opportunity to present today in this session. I'll just share my screen. I'll just a second. Yes, okay. Thank you.
You're welcome.
So just confirm you can see my screen.
Yeah, we see it clearly.
Great. And okay, great. Great. Thank you for inviting me for this session. I hope I will take 15 or less minutes to perhaps go through this session. I'll share the detailed presentation should anyone want to have access to it and consume the information later. So as we talk about international, like looking at how do we benchmark Rwanda with other international players, specifically, of course, the European nations, but also taking a look at Africa, what are other African countries doing? It's important for us to, first of all, just start from an African perspective as a continent, what are we doing? So when you look at data protection from an African perspective, the best benchmark would be the African Union. What are we doing as a unit from the African Union perspective? As individual countries, about 36 countries have data protection laws as of last year, but this might have changed as of today. 16 countries don't have one, or they're in the process of drafting a Data Protection Act. And when you look at from an African Union perspective, only about 15 African countries have ratified it. I'm happy to see Rwanda is one of them. Disappointed that Kenya is not, and other big countries like South Africa, because those are the three countries we are going to benchmark with. So when you look at Europe and what Europe has done, I just gave a brief there where you're looking at European Data Protection Board. That's the one responsible. That's the equivalent of what we are calling the African Union, the Malabo Convention, which is trying to unify or have a uniform way of regulating either cyber or data protection. So that's the European EDPB. And then they have the supervisory authority, which are the national authorities. So the way we have Data Protection Commissioner in Kenya, Information Regulator in South Africa, and also the Commissioner in Rwanda. So from just this approach, it's clear that if you have one regulatory body for an entire continent or 90% of the continent, it means the laws are going to be a lot more uniform. And where there are issues in terms of implementation, for example, if the national authority in Italy has a different fines a company, and then the national authority in France has fined another company, and there's conflict there. They are the ones to help, again, align this. We don't have this in Africa, which presents a lot of problems when it comes to data sharing, especially for companies that have operations in Africa. We are talking about the multinational banks that are in Kenya, Uganda, Tanzania, and you find most of the companies have presence in Kenya, Uganda, Tanzania, Rwanda. They usually have that. So I think with that in mind and with those limitations in mind, I'd like to perhaps just discuss 4 key areas that stand out when it comes to comparing these 4 regions or jurisdictions. So the first one, I think the first introduction, I will not focus so much on it. The GDPR, I don't know if you're aware, but it was enforced 2018. Kenya Data Protection Act, when you compare with the 3, we came in second in 2019. And then we had South Africa 2021, the enforcement, and then Rwanda. So when you look at all this, we all have our data protection authority established, which means we can be able to enforce the law. And in terms of progress, of course, GDPR has so much progress. Kenya, we have so many other cases that we have prosecuted, about 115 and counting cases that we have prosecuted. We are actually in the process of sharing what are these analytics to help companies just know what are some of the risks or where people are being fined. When you look at the 4 areas, regional and extraterritorial, regional application, cross-border, how you transfer data cross-border, and then breaches and data protection role. For the first 2, they are fairly consistent in terms of they are being implemented or what we are saying across these 4 regions. And the last 2, they are a bit different. So I'll just quickly walk you through the 4. And when you look at the first one, which is basically the territorial scope. When you look at South Africa, Kenya, Rwanda, and GDPR, which is the EU, we start by looking at, does the law cover citizens? Does the law cover people who are not citizens, but they are residents, so they are living in the country for a while? Does the law also cover people who are just in transit? For example, I want to go to Congo through Rwanda. Does the law actually apply to me, or does the law also apply to someone who is dead? So there are a lot of consistencies in how the different laws are being interpreted. You find if you're a citizen in a particular country, the law will apply. Especially, and then if you're a resident, meaning you're living in a country, even though you're not a citizen, the law, number 1, protects you in one way or another. If you're a foreigner who is going through that country, let's say you're going in transit and you're passing through the border or an embassy or whatever the case might be, in one or another, the law will be able to cover you. I know there are discussions around the mention of citizens, and if you're not a citizen, because you could be a citizen, but you don't live in a country. But this first one is just the status of the individual. The second is based on the company setup. So for example, if you're a company and you're incorporated in Rwanda or Kenya or South Africa or in the EU, the law is also very consistent in how it applies. And also entities that have a local representative office. For example, I don't think we have a Facebook office in Kenya, but the law will apply to them. So they don't have okay, there's one that have a representative office, but they're not incorporated. For example, like Google, they're not incorporated in Kenya, but they have an office in Kenya. So it applies across board, and that's how the different jurisdictions have interpreted it. Also, entities outside the country that process data of people located in the country. So you're not necessarily in Kenya, and maybe Facebook would be a good example. They don't have a physical office in the area, but a lot of us are on Facebook or on TikTok. There's no office for TikTok, but we are using their platform, so the law will apply to them. Entities processing data of citizens living abroad, and this is what I was talking about. So you'd find a lot of our laws don't necessarily cover the citizens. So you're a Rwandese living in the US. So it might not necessarily cover you explicitly as compared to what the GDPR actually says. If it could be a European living in Europe, regardless, as long as they are a European citizen, it will be able to cover them. So apart from that, the other one is cross-border. So when it comes to cross-border, what also is covered? Like I said, there's also a lot of consistencies and inconsistencies. So for the first part is just the rules. In terms of the rules, our rules are pretty much similar, where we're saying, is transfer allowed? For sure it is allowed. Under what conditions are these transfers allowed? When there's adequate protection in the destination country, and adequate protection could be that this country has equivalent laws. For example, Rwanda and Kenya, we have that. So it could be that. It could be that they meet adequacy decisions. That is the list that the EU primarily has of countries that have relatively higher quality data protection laws. So you'd find you're probably an African country, but you're not on that list because of that criteria. Most of the countries also allow people to share this or transfer data out of consent if the people or the individuals consent to their data being transferred. But also if you have safeguards. For example, if you're operating in Rwanda, Kenya, and South Africa, and you have safeguards, you're a company, you have contracts with your suppliers, you have binding corporate rules which show how you're going to work together, especially these companies that have multiple regional representation. Where we are differing is where we have specific restrictions for public key public infrastructure. So this is where we're talking about, for example, in Kenya, we have defined key critical infrastructure. Banking sector, anyone in the banking sector, things such as our election systems, those are key public infrastructure. Our money and transaction systems, those are key public infrastructure. So where there's sensitive data, national ID, financial data, security, healthcare data, there are very strong restrictions, particularly in the African countries. Where we're talking about national data, national infrastructure. This is where we're talking about your national election systems, your census data, your military data. There's a lot of restrictions, particularly around this within the African countries, not just the three that I've listed there. Public sector, this is government data, so data for ministries. Yes, there's also a lot of restrictions. Cloud, of course, there's a lot of use of cloud, especially with digitization in African countries. So there's a lot of flexibility there. Rwanda being a bit more stringent with not just the data protection laws, but other laws that support the data protection. Just on this, what I wanted to mention here is going back to the first slide, where we talked about EU having one regulatory body versus us having very separate regulatory bodies. That's the reason why when you look at transfers in the European region, it's very easy because they are all following the same law. So it's almost like there are no borders. Whereas for us, our borders are not only physical, But even in our laws are so different, and we've not yet united our laws. The third one is breach notification requirements. So under breach notification requirements, we're looking at what is the definition of a breach? Do you require to notify? Do you notify the authority? Do you also notify the data subject? And I'm happy the previous speaker has touched on this. So when you look at the requirements, they're pretty much the same. In fact, in terms of timelines, we are looking at almost the same timelines. The requirement to notify the data subject is there, especially when the breach is likely to result in harm. The fees are the ones that are different, of course, based on the capacity and the purchase power of the different countries. So you find for EU GDPR, it's way higher, whereas the other ones would be a lot lower. What I can pinpoint for Rwanda and what I like about it is that they have specifically listed some of the misconducts, which include like failure to maintain records. You might think that if you only violate someone's rights, that's where you'll be caught. No, failure to maintain records. And so even in Kenya, that still applies, even though it has not been documented like the way Rwanda has. Failure to carry out personal data logging. These are things that are more processed. They touch on how you're operating more than how you're respecting people's rights and privacy. A failure to report a change after receiving a registration certificate. So it could be a change in name, it could be a change in your financials. It could be a reasonable change. So failure to report that could also result in administrative fines or fees. Lastly is the role of the data protection officer. And this is important because I think at the heart of the data protection law is the people who are running and helping to comply with this law. So when you look at South Africa, Kenya, and Rwanda leaving out the GDPR, you find that the names are different. Kenya and Rwanda, we have the same name, data protection officers. Rwanda, they call them information officers. It is mandatory in POPIA in South Africa. In Kenya, it's not mandatory for every organization to have it. However, the criteria for having a data protection officer, similar to Rwanda, is that you have large-scale processing, you process sensitive data, or you're a public body. And large-scale processing would be, for example, just imagine the bus, let's say an airline that processes a lot of your in and out flights, especially for the national. So that is a large-scale processing. However, I think a bus stop or a bus station that carries a lot of people would actually qualify as that. Trinity, for example, Trinity ships and ferries a lot of us from Kenya to Rwanda, Rwanda to Kenya. That is large-scale processing, especially when you consider the fleet of people who use that service on a daily. The other one is there's a requirement for these information officers to register for South Africa. However, it's not an explicit requirement on these other jurisdictions. What needs to happen is you need to actually forward the names of these people. It's different from registering. And when it comes to qualifications, because in South Africa, they have already defined who qualifies as the data protection officer, the information officer. So we're looking at, for public bodies, these are the Director General is the automatic data protection officer or information officer. For private bodies, again, the CEO or the managing director or someone that they have nominated who meets the qualifications. And then for multinational, so for example, if you have a firm that's you're headquartered in South Africa or you're operating in Rwanda and have a headquarters in South Africa, you have to actually designate or authorize a representative within South Africa for them to operate in that capacity. For Kenya and Rwanda, again, there's no direct requirement that it has to be the CEO or it has to be whatever. But the requirement is this person has to have independence. They have to report to the highest authority within their line. And they also have to have expertise in executing data protection mandate. They have to understand data protection laws. So those are some of the similarities and differences. I know my 15 minutes are up, so I will wrap up by just maybe highlighting when it comes to companies that are operating in these three regions, maybe what is the way forward? Our laws are not the same, but there are a lot of similarities, and most of us are borrowing from GDPR. So it would make sense, especially if you're primarily operating in Africa, to have a unified data protection framework. And this framework would guide you in a lot of the things, such as, for example, like just the data protection officer role. If you're in Kenya, Uganda, and Tanzania, that might not be a problem. Or Kenya, Uganda, and Kenya, leave alone Tanzania. Kenya, Uganda, and Kenya, that might not be a very big problem. But if you introduce South Africa, you now have to think about what are the differences in that role, meaning you have to have someone in-house in South Africa. So identifying those key differences is important, even differences in the penalties that are there and the offenses. The second one is to adopt international best practices such as GDPR, because it also covers and helps you have a global look in your compliance journey. And of course, developing processes, cross-border inventory to track based on the different regions. The second one is to appoint a regional data protection officer or a compliance team, because our laws are very different and they keep changing. Right now, for example, there could be a lot of changes. In Kenya, we've just finished public participation for a guideline that would be mandating that all audits are conducted or should be conducted by data protection certified auditors from the data protection office. So things are changing. So it helps to have a regional approach when you're looking at this. The other one is just to harmonize your cross-border transfers, particularly if you're dealing with very sensitive information, if you're a healthcare facility and you're sharing information across. If you have, especially like healthcare facilities that have international look to it, if you give insurance for international travels, probably you need to have a look at that. And then aligning offenses and penalties, breach and notifications, and incident response. So those are the main things I would suggest you have a look at as you're looking at Africa as a whole. To wrap up, I'll probably invite you to look at there's a map that a team of us, is called Ignite, has worked on. And there's also a toolkit that a group of young professionals, a few of them from Rwanda, have worked on. It's still work in progress, but it would help you keep up with some of these changes that are happening when you talk about Africa specifically and the data protection requirements within this region. Allow me to stop there. Over to you, Silas.
Yeah, thank you very much for your nice presentation. So you gave us a very good overview of data protection laws in different countries. And it's now time for the next session. Without a delay, let's see the next session. So our next session is exploring international data protection. So I would like to invite Musa Wesuta Wakabi. So I don't know if I pronounce correctly your name. So you can give us this session on cybersecurity and data protection and compliance. You are welcome.
Thank you very much, Silas. I don't know if you can hear me.
Yes, we hear you very well.
Okay.
Hear you.
So, thank you. And I have both the curse and the benefit of going last. The curse because a lot of the things have already been said. So I'll try as much as possible not to repeat what the previous speakers have said as I try to add some value to the discussion. So let me just share my screen. Let me know when you can see my slides. Okay. You able to see my slide?
Yes, you can put it in a full screen.
Okay.
Yeah, very well. We see.
Hey, thank you. So as I've said, a lot of the things that I'm going to talk about here, Brensil talking before me and Rosine have also mentioned, but I'll try and just focus on some of the things that I think are key and important for us to think about as we're going ahead to implement data privacy. Now, maybe just to start, first of all, to introduce myself. So my name is Musa Esuta. I am the co-founder and the current group CEO of Sentinel Africa Consulting. And Sentinel Africa Consulting is a risk management consulting firm. We're a boutique risk management consulting firm. We have presence in Kenya, we have presence in Uganda, and we also have presence in Rwanda. So we've been present in Rwanda since 2021, and actually we've been doing a lot of consultancy work, helping organizations to implement frameworks around risk management, and even more specifically, frameworks around data privacy. And so some of the things that we do a lot, apart from just the work around advisory, is we provide training. So that's basically just giving a nutshell in terms of what we do and where we are present currently. So just going into what, I'll try and be a bit brief because I also have the 15 minutes, but just to bring it now, add more to what has already been said. Now, the previous speaker, Brensil, was talking about the global standards that are there. And I just want to touch on that briefly before I go into the specific parts of securing your data. Now, when you talk about privacy protection in the world, actually, we have 4 legal models that are usually followed. So we have the comprehensive model, the sectoral model, co-regulatory model, and the self-regulatory model. So the comprehensive model is what we currently use. So if you look at the laws around Rwanda, the laws around Kenya, GDPR, for example, it follows the comprehensive law. So where you have a very structured way in which the law has been formed, going through public participation, it goes through parliament, and then it is pushed out, and you have it followed fully throughout the entire jurisdiction. Then you have sectoral laws, which are basically sector specific. So you have things like in the US, you have HIPAA, for example, which is specific to the health industry. So you'll see it a lot more in the US. You have self-regulation model. In this model, you have industries coming up with their own codes of practice. So that's really what you have also in the US and Canada a lot, where they are doing their own self-policing. Yeah, so you have those kind of things in the banking sector, for example, they will do their own self-policing. And you also have the co-regulatory model, okay, which combines both self-regulatory and legislative, where you now have, for example, a regulator, like I said, in the banking industry. Now you'd have the regulatory body coming in to sort of like act as the regulatory body there in terms of that data privacy. But then when you look at our own laws, we follow the comprehensive model. So just looking at it globally, you can see that we have really moved ahead in terms of legislations around this part of the world. So you can see Kenya is there. We also have Rwanda, we have Uganda. Tanzania, the law was actually enacted by parliament, expecting it to be approved by the president. It actually is a law that actually has been enacted as well in Somalia. So that is a very recent development. There also is a proclamation in the Ethiopia law, which actually has come to place. So you can see that even just regionally, looking at it, there's a lot of move towards ensuring that we have laws around data privacy. Okay. Now, as we go into understanding this thing about privacy, we also have to consider security. And so what is security and what is privacy? So I just wanted to just indicate here and show you that there is a similarity, but there's a difference as well. When you talk about security, you're really focusing yourself on these 3 ideas. These 3 items. So you talk about confidentiality, which is around protecting the sensitivity of information. Then we talk about integrity, which is around ensuring that data is complete, right? And also availability, which is ensuring data is made readily available as and when it is needed. However, when you talk about privacy now, we have to talk about things that have to do with the regulation. We have to talk about things that have to do with the rights of the data subjects, as Rosine mentioned during her presentation. And so those things come together to ensure that now we are protecting the personal information. So privacy really and security work hand in hand. It's just that we are now focusing in terms of the scope of the security is now on what we call the personally identifiable information. So we always say that you actually cannot achieve privacy without security, right? Because you need to have security in place to make sure that you're protecting the privacy of the PII, the personally identifiable information. Now, when you talk about PII, again, Rosine already mentioned this. This is what we are trying to protect. This is the information that you have as an entity, right, that belongs to your data subjects. Now, this information has different levels of sensitivity. Now, remember, this is your information, right? You have a constitutional right to your privacy. Every human being has a constitutional right to their privacy of their own data. However, your own actions, by your own actions, you can actually change the sensitivity of your PII. Okay, how can you do that? Now, think about going to LinkedIn, for example, and then indicating that, you know, your current employer is this, you've been in this previous employer was this, you were in this school, you know, this is your phone number, and then you say this is publicly available information. Now, when I go to LinkedIn and I find you there, I find your number, I find all that information, then, you know, I could use it, but then it's still sensitive information, right? But then by your own actions, you have made it less sensitive. So again, just remember that you play a role in the protection of the privacy of your own information. So this is something that I really like to emphasize, that we ourselves as individuals also have to be aware about the actions that we actually take, and then we end up, you know, exposing our own information out there. Actually, there are some services out there, especially for recruitment, that allow recruiters online, right, to actually scrub the internet, and they're able to get a lot of, you know, very good profiles, yeah, even indicating psychological makeup of people, right? And all this is actually just coming from publicly available information that you have pushed out. So that's something also to remember, that your own actions could actually end up making your data, which you consider to be sensitive, to actually become less sensitive. Now, there's some entities we talk about a lot. And again, Rosen mentioned this, but I just want to give it some more detail. We talk about a data controller, we talk about a data processor. So when we have the data, this PII we are talking about, the entities that end up processing it will either fall into the two categories. One, you're either going to be a data controller, or you're either going to be a data processor. And so the difference is that with the data controller actually has interacts with the data subject. The data controller is actually the entity that determines the reasons why this processing should happen. Okay, so think about the interaction you have with an entity that you're sharing your PII with. If it's direct interaction, that tends to be a data controller. So could be an employer, be a data controller, a bank getting, you know, bank opening, account opening, right? That would be a data controller. Now, a data processor, on the other hand, they do the processing of the data, okay, but based on the instructions of the data controller. So a data processor then, in that respect, will rarely have a direct one-to-one interaction with the data subject. They have an interaction with the data controller. So they process data upon request of the data controller. So sometimes is it possible to be both? Yes, it's possible to be both. You could actually be a data controller because you have, for example, employees, so you have their data, and then you have a contract by another data controller, and you're processing on their behalf. So that's how to look at this. So upon registration, it is important to determine who you are, right? And I'll talk about it some more just now. Now, because I've been comparing, I'm also comparing between the laws that we have around, so the Kenya, Uganda, and Rwanda. There is an entity. Let me just skip this and take you to the entity. Yes, there's an entity called a data collector. Now, the Uganda law is unique in this sense. It has a data collector. Data collector is now a third entity. Now, a data collector, according to the Uganda law, is an entity that is responsible for just collect, like the name suggests, yeah? They actually physically go out and collect data. Think about a census or think about an organization that is, has a campaign for account opening. For example, like MTN is trying to do a campaign to try and get people to sign up. So then they'll go out there into the countryside. They'll have hired a third party, and that third party is going out there to physically get information. So that party, that entity, in this sense, is called a data collector. But according to the regulation in both Kenya and Rwanda, we don't have a data collector. We just have a controller and a processor. Now, let me just take you back here. So this is the relationship. Now, the data subject being you, who has your personally identifiable information, you are actually then sharing, or you're giving your data to the data controller, okay? The data controller has to process this data according to some legal basis, right? Which again, Rosine alluded to. So they must have a legal basis for processing this personal identifiable data, which they are being given by the data subject. The data controller might, right? It's not a must, but they might actually outsource this processing to a data processor. And when they do, that means that they will have a data processing agreement between them. The data processor will then be processing and then giving the data controller back the result of the processing. Okay, so that's the relationship there. Then the data protection authority, or the supervisory authority, right, which in this case is the NCSA, they then have the mandate to audit both the controller and the processor, right? And that's their role. So this is typically the relationship, and you'll see this with the GDPR, you'll see it with the Kenya DPA, you'll see it with the Uganda DPPA, and you also see it with the Rwanda law, right? It's the same kind of relationship, okay? Now, let's proceed. An important question to ask yourself during registration is, are you a processor? Now, typically, why am I talking about processor, not controller? Typically, if you have employees, you're a controller, typically. So typically, most organizations are controllers. The question that organizations usually ask themselves is, are they processors? Okay, so that's usually the question. So are you a processor? So we have a simple flowchart here, yeah, that can help you to answer that question. So first of all, ask yourself, do you handle personal data? Yes or no? Yeah, if you don't, then of course, you shouldn't even be here, right? Now, you handle personal data. So yes, you ask yourself, do you determine the purpose and the means? If you do, you're not a processor, you're a controller, right? So if you know, we go to the next question. So do you process PII on behalf of other organizations? If you don't, then you're not a processor at all. Because remember, even controllers do processing. Processing is all those activities around storage, transmission, all those activities that you do to PII are considered processing. Okay, so even if you have CCTV cameras in your building, and you're doing surveillance of individuals who come in and walk around, that is actually considered processing, right? So let's remember that even data controllers are doing processing. So if you're processing on behalf of another organization, then we continue. And we ask the next question, do you follow the instructions of anyone? If you don't, then you're most likely going to still be not a processor, you're probably going to be a controller. But if you do follow instructions, right, in order for you to do the processing, then you are a processor, right? The other question to ask yourself is, if you're involved in decision-making. If you're not involved in decision-making, then you are a processor. If you are involved in decision-making, what this could mean is, you might have a scenario where you're a joint controller, right? So what's a joint controller? Joint controller is a scenario where, think about, maybe you're the customer of a bank. Let's say you're a customer of BK, and you're still a customer of MTN at the same time, right? So there will still be a scenario where both of them are processing your data. So you have Momo on this other side. So you've connected your Momo to your bank account, right? So you're able to transact, right, through your Momo all the way to your bank account. So both of them are actually controllers in that scenario. Okay, so again, depending on the scenario, if the entity is still involved in decision-making, they will still be a controller. But in that scenario, there are joint controllers. You have two controllers who have both the PII of the data subject. Okay, so again, it's important for us to know why, because you need to make this decision very clear, distinction rather, when you are registering. So let me take you through the registration. I'll talk about registration in Kenya. We'll talk about registration in Uganda, and we'll talk about registration in Rwanda. So with Uganda, the Data Protection Office is called the PDPO. This is the supervisory authority, so you register with them. Registration is through their website, so they have a portal. So you register, so the link is down here, pdpo.go.ug. Register, you'll see interface like this, put in the required information, and then you go through it, and then you follow, and then you register. So there's some documents that you're supposed to upload. The thing about the Uganda registration is that it actually has a fee, and they charge 100,000 Uganda shillings, and there's no distinction about whether you're a processor or whether you're a controller. Coming to Rwanda, I think Rosine mentioned this, so I'll go a bit fast on it. Again, registration is through the NCSA. So there's a DPO, which is within NCSA, where you register. So registration is a bit manual. So you actually have to download the registration forms. You'll have determined whether you are a processor or a controller. Then you register as such. If you're a controller, you register by filling in the forms for the controller form. If you're a processor, you do. If you're both, you do both. Okay. These are some of the requirements. As a highlight of some of the administrative documents that you're supposed to provide when you are registering. So I think Rosine mentioned this. I won't go too deep into this, but then this third schedule is the documents, a list of the documents that you're supposed to provide when you are doing registration. So the forms, I've just broken them down like this. I shall share this PPT so you can actually go through it so you can understand what are the things you're supposed to fill in. So, but there are different sections, and different sections require you to provide different types of information. So you go through that, listing all the information that is asked for. Then after that, you submit to the NCSA. Okay. Again, the difference with Rwanda and Uganda is that Rwanda is actually free. Now, Kenya, registration under the ODPC is a bit different. First of all, there is an identification of some data controllers that we say have a mandatory requirement to register. So any controllers that have been determined to be in this kind of activities, political canvassing, crime prevention, gambling education, health administration, hospitality, right? All the way to entities that are processing genetic data. These entities are required to register regardless of how much they earn or the number of employees. So the registration in Kenya depends on two things. Depends on how much the turnover of the organization is, what's the annual turnover, and how many employees the organization has. So the three categories are the micro and small data controllers, and then you have the medium data controllers, and then you have the large data controllers. So the medium, the small and the micro and small have between 1 and 50 employees, and they must have a turnover of a maximum of 5 million Kenya shillings, which is approximately $50,000. So those kind of entities are considered micro and small, and then they will register by paying a fee of 40,000 Kenya shillings, and they will be renewing after every 2 years by paying 2,000 Kenya shillings. The medium data controllers are those entities that have between 51 and 99 employees and is bold, right? A turnover of between 5 million and 1 and a maximum of 50 million. Okay, so then they pay 60,000, 9,000 at renewal. Large is more than 99 employees and an annual turnover of more than 50 million. Okay, they pay 40,000 and then 25,000 upon renewal. So that's how it works. Now, we have charities and religious entities. Charities and religious entities, regardless of how many people they have, regardless of the turnover, simply pay 4,000 upon registration and then 2,000 in renewal fee. Public entities, that is ministries, departments, agencies, right? Public sector, they also register by paying 4,000 and then 2,000 upon renewal. Now, there are some exemptions under the Kenya regulation, meaning that there are some data controllers who are exempted from registering. Now, it doesn't mean that you're exempted from the law. You still have to process, data that belongs to data subjects according to the law, but you're exempt from registration. So those entities with an annual turnover that is below 5 million and have less than 10 employees. So they have to meet both those requirements. So if you have less than 5 million and you have less than 10 employees, then you're exempt from registration. However, an entity that has more than 5 million but less than 10 employees would fall under the small and micro. Also, vice versa is true. If you had more than 10 employees but made less than 5 million, then you'd fall under the small and micro. That is why the and here is very important. So that is around registration, which is the first thing that you're supposed to do when you are seeking compliance. And I think Rosie mentioned that when she started. The first thing that you do is to do registration. It's not the end, it's the beginning. That this is just an example of how the different certificates look like. So as I said, as an organization centered in Africa, is in Rwanda, we're in Kenya, we're in Uganda. So as a requirement, we have registered as data controllers in all the 3 jurisdictions, just to show you a bit how they look like. They're similar, bit different. So this is what you get when you register with the NCSA. It will show very clearly the logo there shows NCSA, and it's the DPO, the Data Protection and Privacy Office within the NCSA. This is the certificate you'll get. You'll have a registration number, you'll have a validity date there, and then the issue date. Okay, it will show your company and it will show you've been registered as a data controller. If you are a data processor, you'll have another, right? So you'll have 2 certificates. The Kenya one looks like this. It has a logo of the Office of the Data Protection Commissioner. That is the ODPC. It shows the name. It will show you the registration number as well. And then it has a QR code here that you can use to verify, right? This is the Uganda one. It comes from the Personal Data Protection Office, the PDPO. Again, it will show the name of the company. It will show the registration number. So you can see they're very similar, yeah? And then it'll have a QR code which you can use for purposes of verification. So that's what you get after you've gone through the process of registration, okay? Now, let's talk about a few things that are also a bit different. Now, breach notification. Again, Brensil has talked about breaches. So I'll be very brief on this. A breach, what is a breach? A breach is basically anything, any incident that would lead to loss, yeah, destruction, corruption, right? Or unauthorized disclosure or alteration of the personal data. Now, this can either be intentional or accidental. So remember that even if it happened by accident, it will still be considered a data breach. And so when it is a data breach, right, it could cause material or non-material damage to individuals. So you're supposed to then do something about it. There are 2 things that you do. One is notification. Now, notification requirements are this again, I'm comparing the 3 jurisdictions that I was looking at. In Rwanda, notification requirements are within 48 hours, the data controller must notify the supervisory authority, which is NCSA, within 48 hours. In Kenya, the data controller must notify ODPC within 72 hours. And Uganda does not explain the time, but it says immediate, right? So that I'm sure will be clarified when they come up with the regulations that support the law. Data processor has to notify the data controller. Okay, so the data processor notifies the data controller. Remember, the data processor is supposed to support the data controller in their obligation towards the law. Okay, so the data processor must notify the data controller within 48 hours. That's similar in Rwanda and Kenya. In Uganda, again, it says immediate. The data collector is not an entity recognized in either the Rwanda or the Kenya law, but recognized in the Uganda law, who is also supposed to notify immediately. Now, after notification, we have something called reporting. Okay, now the Rwanda law specifies reporting. That's very different from the other laws. The other 2 laws do not talk about reporting. The other 2 laws just talk about notification. So now when it comes to reporting, the expectation is that the data controller will then come up with a report, okay, on that breach and submit it to the NCSA, okay, within 72 hours. So I hope you are understanding the difference. So you're supposed to notify within 48 and then submit a report within 72, okay, which is very unique and very specific about the Rwanda law. You don't hear that in the other laws. Now, as you are coming up with the report should be a structured report. So it should have the details of the data breach. It should have the details of the DPO. It should have the consequences. You need to describe what happened, what is the impact, okay? And actually describe what are the measures you have taken, right, to address the breach. The other thing you need to consider is there an impact, right? What we call, is there a risk to the rights and freedoms of the data subjects who have been involved in this data breach, or who have been affected, or who might be affected in this data breach? Now, an assessment needs to be made, and that's why the DPO has to be somebody who is very, knowledgeable, not just in the business processes, but also in the law. So the the DPO has to help to do the assessment on the risk that is posed to them, rights and freedoms of the data subjects after the breach occurs. Now, based on that, if you determine that the risk is high, then they also have to be notified. Okay, you need to notify the data subjects. Okay. Enforcement, quickly, again, this has been mentioned, so I'll talk again about the 3 laws. On the Uganda side, the enforcement is an equivalent to 4.9 million Uganda shillings, right? Which, according to their act, is actually, they do the math according to currency points. So they have something called, currency points. So any non-compliance act will attract a fine of 245 currency points. Now, the current currency point is equivalent to 20,000 Uganda shillings. So with 245, it comes to 4.9 million. The value is set by the ministry. So in case in a year or 2 years or 5 years, the ministry changes it from 20,000 to 50,000, then the 245 currency points will remain, but then the actual value will keep varying depending on how much a currency point is, and this is something that is determined by the ministry, okay? Then we have on the Kenya side, so the Kenya side, I think Brensil also touched on this, the enforcement, we have the law, and you can be fined up to 5 million or $50,000 equivalent approximately, or up to 1% of the undertaking's annual turnover of the preceding year. But then Kenya law talks about whichever is lower. In the GDPR, it actually goes up to 4%, right, of the global annual turnover, whichever is higher. And that's why you see some of these fines are mind-boggling, yeah, that come from the EU. Like the CNIL is a supervisory authority from France, which has, had the record of fining up to billions of dollars, yeah, Google and Facebook and those guys, right? So that's the scenario. So you can see we are a bit more easy, if I can call it that, right? Yeah, then there are still some penalties that would come under the act. So you have 3 million, that is for administrative penalties, administrative fines. And then also remember, it doesn't mean that because you've attracted a fine that the data subject cannot take you to court. The data subject can still take you to court, right, to actually get some reprieve under the law. So this is to file a complaint under the in Kenya. The link is there. It's in the portal. It's as simple as just going to the portal and then putting in the details and filing a complaint. The NCSA, on the other hand, so the administrative fines, we talked about them. We have between 2 million and 5 million Rwanda franc, or 1% of the global turnover of the preceding financial year for a corporate body or legal entity. Now, this is a bit different. Again, you can quickly see we're talking about global turnover when you're talking about the Rwanda law. In the Kenya law, we're not talking about global turnover. We're talking about annual turnover. So it's a bit light on multinationals, but when it comes to Rwanda, it's a bit heavy on multinationals because then it pulls in the global turnover of the multinational, similar to the GDPR. The GDPR also talks about global turnover. So multinationals then have to be very careful about ensuring that they are actually complying to the regulations, okay? So again, this has been mentioned by Brensil, so I don't want to focus too much. Just wanted to show you something. I think it was mentioned when Brensil's presentation that the ODPC, this is the Kenya Supervisory Authority, is actually dealing with a lot of complaints. So myself, my hand is up, this is mine. I actually filed a complaint. So it actually works. So this is a complaint that I filed last year, and then the case was heard, and this was the final determination that entity, that data controller, was actually found to be liable, and therefore an enforcement notice was issued to them. And so this is something that just wanted to bring to your attention, that it actually works. So the difference, I guess, is how much mandate the different supervisory authorities have. The ODPC has the mandate to actually push a fine and actually enforce the fines. The PDPO in Uganda does not have that ability. You must go through the route of court, right? NCC has, but we've not seen that individuals have been filing complaints, and complaints have been going towards being determined, and we're yet to hear of a scenario where somebody has actually been fined. But I mean, that is just a matter of time. I won't belabor on this because it was mentioned by Rosine, talked about the legal basis for processing of data. Maybe just to emphasize one thing, we talk a lot about consent, right? And we say that consent is where the data subject has given you permission to process their data, right? Now, one thing to realize about consent, it's actually not the first legal basis for processing that you should go for. It should be the last. Okay, you go for consent because you don't have any other legal basis, or because the initial purpose of the data processing has changed. So let me give you an example. If you go to a hotel, a restaurant, you pay, yeah, and as you pay, they get your data. Let's say you pay using Momo. So if you pay using Momo, of course, they will have your phone number. So the purpose for them processing your phone number and phone records was what? For you to for them to facilitate the payment. Now, once the payment has been done, they'll have your phone number. Now, if they want to do something different, if they want, for example, to use your phone number to send you, any kind of brochures or marketing or ads, then they need to ask for your consent. Why? Because now the purpose has changed. Okay, when the purpose changes, then you need to go back and ask for consent. The other reasons why you ask for consent would be, like, for example, if we are trying to transfer data, to a third country, and we don't have any other basis. For example, contract, we can't use contract as a basis. We can't use legitimate interest as a basis. Then we can come back to you and ask for consent. So, but consent should be the last thing. Let me give you a scenario. Let's say you are in company, right? And we've seen in Kenya, there's a company that was actually fined because one of the employees complained that they used that employee's picture in their marketing, on their website and their brochures and those kind of things. So the employee complained and said that they'd used my image and all that. And this is a former employee. Okay, so the organization then goes and says that this employee had given us their consent to use their image. Okay, now this employee is no longer there. Yeah, so can you still say that consent applies, right? But anyway, I digress. Let me come back. Imagine a scenario where the organization is saying that we are going to monitor every activity you do on your computer. We're going to monitor everything you do when you walk in through this door. When you are in this building, we'll monitor everything that you do within this building, okay? Because this is work. But here is a form to sign. Sign your consent. Now think about it as an employee. Really, can you fail to sign that consent? What does it mean if you don't sign it? It means that you don't have a job. So there is no there's no way you're going to refuse to sign that consent. So therefore, it's the power dynamic. There's a power imbalance. The organization does not need to ask for your consent in that scenario, right? The organization needs to show that they have a legitimate interest in processing that data, and so therefore they don't need to ask for your consent. They'll just have a legitimate interest. Okay, so one of those things that organizations don't really take time to understand is this legal basis called legitimate interest. If I walk into the bank today, or I walk into any any mall, right, or any building, I'll find that they have CCTV, right? But then there's nowhere they ask me for consent for them to do their surveillance. I'll just see a notice they're saying this building is under 24-hour surveillance, right? So the building is still processing my PII as I walk through the corridors, but then they have a legitimate interest for doing that. So they don't need to ask me for consent. Okay, so it's one of those things where we try to really advise organizations, we try to advise data protection officers, especially during our trainings, that you actually can seek this as a very good way of still processing PII without forcing the organization to keep asking for consent forms left, right, and center. Last thing about this, before I move on from legal basis, there's been a lot of organizations or people, panicking and putting up notices and saying, if you're going to come into this, we've even seen them in weddings, especially in Kenya, where you see a notice when you're going to someone's wedding, and the notice says, by you walking into this event, you're given us consent to take your photos, right? And so that is supposed to be consent. I mean, if I read a notice on a wall and the notice is saying that if I walk in here, then that constitutes consent, that is not consent, because consent is something where I actively say yes, but I can say no as well. Okay. But in a scenario where I can't say yes or no, that's not consent. Another thing would be, if it is supposed to be consent, it means that I can withdraw it at any time, right? So how can I withdraw the consent? So if I walk into the event, then how am I withdrawing it? By walking out, you already have taken my photos, you see. So it's supposed to be DPOs. It's a requirement that DPOs have to start to understand that your role in an organization is to advise. And this is something that we really try to emphasize, really learn how to advise your organization about the things that they can do, right? Rather than just running to saying, put a notice, have consent forms, right? So that's just something I wanted to put up there. Now, quickly, let me talk about dark patterns. I think my time is running out, but just to explain what dark patterns are, talking about how we design our applications, how we design our systems, we need to be very careful about dark patterns. So what is a dark pattern? Dark pattern is that design of a system where you are either tricked by the system into clicking something you didn't want to click, or the way the system is designed, it just leads you towards clicking that. Right? You have no option. So an example is where you have these three options and one of them says opt in, another one says don't opt out, another one says don't not opt in, so what is what? Like that kind of thing, yeah? So examples are this, where you have, this is a marketing, right? And you're trying to sign out. And then either it says, click on this. Yes, I want to make it rain, or no, thanks, I want to stay poor. This can look like it's an exaggeration, but I don't know how many of you have shopped on Amazon, for example, and you're trying to check out, and then it asks you whether you want to check out using Amazon Prime or no thanks, right? I want it for free. It makes it look like, there's something wrong with you for why you're not clicking on, you want Amazon, right? Those are called dark patterns. This, are you sure you don't want to not to opt out? I mean, what are we asking here? This, you don't even know whether you should say yes or no. Then the other thing you should notice is the use of colors, right? Usually we'll have yes will usually be a green, and then no will usually be a red, but now they've mixed the colors here, pushing you towards the green. So the human mind, you want to click on green, so that kind of thing. This is also something that happened with Microsoft, right? So there's a time Microsoft was trying to push us from Windows 10, right? And then this was sent to all computers. I don't know if you remember this. And then if you look at it here, there's a dark pattern here because I am required to either click OK, it will start upgrading, right? Or click on upgrade now, it will start upgrading. So I don't have an option, right? And actually, this was so extreme because I remember even when you clicked X here, you'd still upgrade, right? So this is also something that is done by even the bigger guys. Okay. So privacy by default, which is also goes back to improving how we design our applications. You have websites. I'm sure your organizations have websites. Make sure that when you're using cookies on the website, you're making it so clear to the person who's using the website how they can either switch them off, right? Or rather switch them on, because they are all off by default, right? That should be something that you should remember. Privacy by default basically means that the privacy settings by default are set to the most private setting, okay? The most secure setting by default. So if I go to a cookie setting and find all of them have been set off, then I can set them on manually, okay? So that's how it should be. I won't talk about data subject rights because Rosine talked about this already, so that I can talk about the last thing which I want to talk about, which is ISO. So when we talk about implementing privacy, okay, we have talked about the regulations. So I was just trying to show you the difference between the different regulations within the region that we are in. However, ISO helps us, right, to tell us a way, a how. So the law tells us what we're supposed to do, but then when it comes to how can we achieve compliance, ISO is there for us. So ISO has given us a standard, right? And this standard is called ISO 27701. This standard gives us requirements. So once we implement these requirements, we implement a management system against ISO, okay, that helps us to achieve privacy. Okay, now the standard we have is called ISO 27701, but it is in a family of information security standards. ISO 27001 is the de facto standard for information security. Here it is. So 27701 is in this family of 27,000 standards. Okay. So now I'm going quickly, but I hope I'm not losing everybody. So this is 27701. So let me go further into it. In 27701, for you to implement it, your 27001 is a prerequisite, meaning that as you're implementing 27701, you will also be implementing 27001. Okay. Now, coming back to Rwanda, so there is a move currently, okay, that is being pushed by RISA to see that all the MDAs have implemented 27001 and 27701. Okay, that is actually a move. And that's a very positive move, because we've seen that there are organizations around that actually implement both 27001 and 27701. 27701 being for privacy. Okay, now what is it? It's an extension of your 27001. So the requirements you have for information security, remember we talked about the three things: confidentiality, integrity, and availability. Now we add privacy. Okay, so it has that extension. Then it has the specific, what we call PIMS, which is Privacy Information Management System, specific requirements and guidance. So it will have additional requirements that are specific to privacy, and you have the extended interpretation. Okay, so when we talk about information security in 27001, here you're talking about information security and privacy. So they are related, okay? So let me take you into the controls. This will move faster here. Yes. So when you are implementing, you'll find that your 27001 is a standard that has these clauses. It has this clause 4, clause 5, clause 6, clause 7, clause 8, clause 9, and clause 10. Okay. Now, what we are doing here is we are comparing which of these clauses will have additional requirements when you're going for 27701. You'll find that this requirement of clause 4 for 27001, you will have additional requirements for privacy. You will also have additional requirements for privacy in clause 6. However, in this leadership, support, operation, and all that, you will not have any additional requirements. Only the requirements that you already have from 27001 will be required here. But when you come to the controls, which are the things that you implement to secure your environment, you will have additional guidance in each one of them. So there are 93 controls, and all those 93 controls, you will have additional requirements to make sure that you are achieving privacy. Okay, so specific controls have include things like the policies, include things like organization of information security, human resources, asset management, access control, cryptography, right? You'll have all these requirements that you'll have additional requirements on them around privacy, okay? Now, when you look at the standard, it has two clauses. We have a clause 7 and a clause 8. A clause 7 is additional requirements only for the controllers, right? So we have additional requirements that only for controllers. Then we have additional requirements only for the processors. So if you determine that you are a controller, then, or you're only a controller, you're not a processor, you're not required to have these controls in place. But if you determine that you are a controller and a processor, then you need to have both these controls in place as you're implementing your privacy, okay? So this just gives us an example of some of them. So we'll have conditions for controllers around the collection and processing. We'll have controls around obligations to the PII principles, right? Basically, these are the data subjects. We'll have controls around privacy by design and privacy by default. We'll have controls around sharing, transfer, and disclosure. So what you should be picking from this is, let me just go back. What you should be picking from this is the fact that when we are doing our implementation of our privacy, sometimes we can get lost and say, okay, so how do I do this? So what the standard answers is the how. The standard answers that question, how? How can I implement data privacy? Then the standard answers that question, okay? So after you finish your implementation, there is the element of certification. So this is how those organizations are related. So you can find that you are here. So this is an example of a bank. A bank X is here. They will seek the consultant to help them to implement. So the consultant will implement that ISO standard. There will be a certification body, right? For example, CertiTrust is a certification body, BSI, SGS, Bureau Veritas. These are global certification bodies. This certification body will audit this Bank X, and this certification body itself has to be accredited. So it is accredited by an accreditation body which oversees its activities. This certification body audits this organization. This organization gets advisory from the consultant. So that's how it usually works. And then the entity gets then their certification, okay? So that's typically how it works. And I think I have gotten to the end of my presentation. I have more content in these slides, but allow me to stop there so that I can at least share it even after this session. Back to you, sir.
Yeah, thank you very much, Musa, for your nice presentation. So you highlighted the benefits of applying compliance to data protection law, and also you gave us a very good information how we should work online when it comes to accepting cookies, and also when it comes to installing a new software. Sometimes they give you a big document of compliance, and some of us never read. You click on accept and finish installation. So without knowing what kind of data they will take on our side. So we come to the end of our sessions, and thank you very much, the presenters. It is now time for answering the questions. So I did not want to interrupt any presenter because all the sessions were very good to see, and we learned a lot from your presentation. So I request participants to take a short time and ask questions. And also there are some questions which I asked on QA and the chat. So maybe we can start for those questions which I asked. I see 4 on the QA. The first question is, I hope it was sorted out. The presenter's PowerPoint is very small. And the next question from Aline. What does Kenya law say about an international company having a representative in Kenya? Do they have to register the company first, or they can have a representative without registering the company? So the other question from Remy Twagirimana, are media houses or media institutions complying with data security management? The last question from QA is from Francis, who asked whether was the cybersecurity part covered. So I hope we discussed on cybersecurity data protection law. So when it comes to cybersecurity, also we talk about the cyber crimes or cyber misconduct, cyber war, cyber attacks, or are those kind of things which can happen on the internet. So they are well described in the data protection law. So I hope presenters can participate in answering questions, starting from the one from Aline.
I think it's for Kaimba. The Aline's question, I think it's for Kaimba. Yeah.
Okay.
Yeah, I actually think it's for Musa because I know Musa responded to it. The question on registration, when you go back to Musa's presentation, he highlighted that the requirement for registering, it's not really, it's really dependent on which industry you're in. He listed the industries that have mandatory requirements for registration. Betting, financial services, education, healthcare, if you're an insurance company. So those ones are mandatory. So you don't even need to think about it. So if you have a physical office or you don't have a physical office, but you process data of people located in Kenya, you must register. The second option is now everyone else who does not follow in that category, you're not listed there. You then have to look at your turnover and your number of employees. I hope that answers.
Yeah, very good answer. So let us take some other questions from participants. So then we close this webinar. Let's see if there are more questions coming. There is another question from Remy. Are media houses or media institutions complying with data security management?
Maybe I could take a stab at that.
Yes.
So when you talk about the media, I really want to make an assumption that you're talking about the fact that with media, they are going to, especially in these parts of the world, like for example, if you go to Kenya, you'll find there is a very popular show called Jichopevu. And what Jichopevu does is these people do investigative journalism, right? So they will investigate some corruption, they will record some people, making some corrupt deals, and then they will actually televise that, right? So you might see that and you might see, but this was somebody who was being recorded without them knowing. How comes this person is actually able to disclose this information? Isn't it a breach on this person's privacy? Now, but remember, if you're a journalist, right, the journalists also have a law. Okay, so they're protected as journalists because you have to protect their rights again, right? Because they have freedoms and as journalists. So as long as it's a registered journalist and they're doing it out of journalism, then they will still be able to disclose some of those things that might be actually be considered private in nature. So by just going by that definition, if it's out of journalism, then yes, they will be processing or disclosing things that you might not be able to do yourself. However, when it comes to the other requirements under the law, when they are processing data that belongs, for example, to their employees. Now, I'll give you the case of Kenya again. The entity I was talking about, who the employee actually complained that they had actually used their image, was a media company. Okay, and they were held liable. In Uganda, a media company was also held liable for flouting of data privacy regulation, right? So they are still going to be required to follow the law.
Okay, so I don't see more questions. Any other question? If no more questions, our webinar comes to the end. So I take the time to thank you for participation and especially for the presenters of today. Still, we need more webinars like this one to explore other parts where we see the integration of artificial intelligence in our daily life. So we should know how to deal with decisions made by artificial systems. So let's say if they deny a credit in a bank based on a recommendation of artificial intelligence, I hope as a data subject, you have a right to ask why the credit was denied, was not given. So I am in data science and my main focus is on explainability, where I try to give more explanations why the artificial intelligence, which works in a black box mode, can be generate explanations which are human interpretable, so that you can give more information why a decision was made. So I thank you very much, and Musa, I saw how you presented things regarding personally identifiable information. So I am also much concerned about the personal identifiable information when I work with patient data. And I tried to make sure that I identify the data so that no one can go back and trace which kind of data of a particular patient. So thank you very much from Africa Quantitative Sciences and from Rwanda Cybersecurity Authority, and also from Norwegian community and other participants. So I was your moderator, and now our webinar comes to the end. So I really appreciate your work and how you push things to the right so that the people can be aware of what is going on in terms of data protection law. So I see Rosine is calling. Maybe she wants to say something before we close.
Yeah, thank you so much. I saw on the agenda that we have our speaker, the CEO of Africa Quantitative Sciences.
Oh,
Yeah.
okay. So if he is with us, he or she is with us, we can dedicate a time. Yeah, no problem. Yeah.
Thank you, Silas, and thanks for the
Yeah, you are
amazing.
welcome.
Thank you very much. And I can't thank enough Musa, who's the last presenter, for the
Yeah.
way which he shared. Brenso, Rosine as well. Super grateful. And I concur with you, Silas. We should have more of these because we learned a lot. Us as CEOs, there's a lot we need to be careful from now on. We don't want, we hate those lawsuits. So
Yeah,
thank you
for
very
sure.
We can't thank enough those who secure time, our partners who agreed to spare time on a Friday to come and listen to this webinar. So thank you all, and hopefully we will see you again all soon, talking hopefully about AI and cybersecurity. So wish you an amazing weekend. Thank you, Silas.
You are welcome.
Thank you all. Have an amazing weekend.